What is the difference between a wetland conservation reserve and a Ramsar site? How does the recent Supreme Court judgment affect the protection around a wetland conservation reserve and Ramsar site in India? Which is the state that recently launched a mission to protect clouded leopard in India? Welcome to another session of weekly environmental current affairs powered by Amrita IAS Academy. I am 𝐂𝐿𝐵𝐸𝐶. Let's begin. The first news is an explained article from the Hindu. How will the Supreme Court order impact mining around Ramsar wetland site? So first we have to see what is the Supreme Court order. So we have to see the context of this news. So the context is that in 2024 related to a hearing of TN Government Tirumipadu versus Union of India case. So this is a very famous case related to environmental justice in India. This is otherwise known as forest case. So for the purpose of this class, I am not going to discuss what is this forest case or what is this TN Government Tirumipadu case, but related to a hearing in 2024 about the case, a order was passed by the Supreme Court related to Assan Conservation Reserve in Uttarakhand. So Assan Conservation Reserve is a conservation reserve in Uttarakhand, and it is the first Ramsar site of Uttarakhand. So not that it's a conservation reserve in Uttarakhand, not only that it's a conservation reserve, it's a Ramsar site. So hope everyone know what a Ramsar site is. So Ramsar site is any internationally recognized site as a part of the Ramsar Convention, which was held in 1971 in Iran. The Ramsar is the place in Iran. Okay, so Assan is the first Ramsar site in Uttarakhand, Uttarakhand, not UP, Uttarakhand. Okay, so here, as a part of this case, as a part of hearing in this case, the Supreme Court has held that mining within 10 kilometers around the Assan Conservation Reserve cannot be done without permission either from the Standing Committee of National Board for Wildlife or from Ministry of Environment, Forest and Climate Change, the central ministry. Okay, so this was the case about Assan Conservation Reserve. So this happened in 2024, and within 2 years many cases happened across India, and now Supreme Court headed by the Chief Justice of India has clarified that this decision, the Assan Wetland Conservation Reserve, the case related to that, and whatever the decision had taken in that case is also relevant for all other community reserve or wetland conservation reserve across the country. That means, so this was clarified by Justice Jomyala Bagchi observed that whether there is a community reserve or wetland conservation reserve, the direction issued in the Assan case would apply for the sake of parity. So equity is there. The meaning is that earlier in 2024 judgment, 10 kilometer around Assan reserve in Uttarakhand, mining could not have happened without getting permission, and this has been extended to all other conservation reserve or community reserve across India. This is the case. Now we have to see what is a conservation reserve, what is a community reserve, and how is it different from Ramsar site. Okay, so according to the Wildlife Protection Act, of 1972, various protected sites were given legal status. So national parks, wildlife sanctuaries. So you might be clear about what is a national park, what is a wildlife sanctuary, and there are other kinds of reserves as well: community reserve and conservation reserve. So these are legally recognized protected sites in India according to the Wildlife Protection Act of 1972. But you have to be very clear about the point that I am going to say next. Okay, Ramsar sites are not recognized under any of the Indian Act. Many of the Ramsar sites are actually wildlife sanctuaries or conservation reserves or community reserves. And since those Ramsar sites are wildlife sanctuaries or community reserves or conservation reserves, they are protected, legally protected under Indian law. But most of the Ramsar sites are not considered a wildlife sanctuary or community reserve or conservation reserve or national park for national park. Okay, so you have to be very clear about this distinction. So Ramsar sites and wetland conservation reserve are different, and the recent Supreme Court order is only for wetland conservation reserve and community reserve, not for Ramsar sites, not related to Ramsar site. So Ramsar site is an international designation, while wetland conservation reserve is a domestic legal designation under the Wildlife Protection Act of 1972, while Ramsar site is recognized under the Ramsar Convention of 1971. Okay, so that these Ramsar sites does not automatically create a 10-kilometer mining buffer. That's the important thing that you have to note here. And the Wetland Conservation Reserve, according to the recent Supreme Court judgment, can attract statutory wildlife protection. That means create 10-kilometer of mining buffer according to the recent Supreme Court judgment about Wetland Conservation Reserve. Okay. So that's the main difference between Ramsar site and Wetland Conservation Reserve, and this is how the recent Supreme Court judgment will affect the protection around Ramsar site and a Wetland Conservation Reserve. And you have to understand that the Wetland Conservation and Management Rules of 2017 is the rules which is formulated to protect wetlands in India, and understand that the rules of 2017 is the domestic framework for wetland conservation in India, and these were notified under the Environmental Protection Act of 1986. And this rule has essentially decentralized water wetland management, and state and union territories wetland authorities were formulated under this act, and the identification and notification of wetland will be done by each state and union territory right now. And the Ramsar Convention, Ramsar sites are actually identified by the central government and notified by the Ramsar Convention. Okay, so understand that the preparation of integrated management plans of various wetlands will be done by the individual states and union territories, and regulation of various activities in that wetland also will be done by the state and union territory wetland authorities. So this is not related to Ramsar site. The Wetland Conservation and Management Rules 2017 is not directly related to Ramsar sites. Most of the Ramsar sites are regulated under this rules, where states or union territories will regulate activities in that Ramsar site. Okay, so the Wetland Rules 2017 do not establish a universal 10-kilometer mining buffer around Ramsar site, while the recent Supreme Court order extend 10-kilometer protection around Wetland Conservation Reserve. That's the important thing that you have to note. So it's not according to the Wetland Conservation and Management Rules of 2017 that the Supreme Court has ordered that a 10-kilometer protection buffer should be there for mining around the wetland protected area. Okay, around the wetland or conservation reserve or community reserve. So that's all from this article. Let's check out the next article. Next article is related to a species. Meghalaya launches mission to protect clouded leopard. So what's the importance of clouded leopard? What are the features that distinguish clouded leopard from other big cats? So this is a small cat actually. Okay, so the distinctive features of clouded leopard include the cloud-like marking on its coat. So that is where the name of this leopard comes from, cloud-like marking. And this has got exceptionally long tail. So you can see the long tail here, right? And these are highly arboreal in nature. Arboreal means they live in trees. So since they are living in trees, they have the ability to climb trees and ability to climb down trees head first. So in this picture you can note here that this clouded leopard is climbing down the tree head first. That is one of the important feature of this clouded leopard. And understand that this is the state animal of Meghalaya. So while this is the state animal of Meghalaya, now we have to see the range and IUCN status of this clouded leopard. So IUCN status is vulnerable. This is not that important. I would not prefer to study this IUCN status at all for prelims, because in the last 15 years only 2 times IUCN status was asked. So if you are able to remember the vulnerable status of clouded leopard, please do that. Otherwise just don't give emphasis on that. Then the range of clouded leopard also should be noted. This is actually predominantly seen in northeastern India, and it's not endemic to northeastern India. It's actually seen across this region. Okay, so it's not endemic to northeastern India. It's seen in India. It's seen only in northeastern India, but it's not endemic to India. It's actually seen in many other countries in Southeast Asia and East Asia. Okay. So that's all from this article. Let's check out the next article. This is another explained article from the Hindu. Can floating solar boost India's renewable energy uptake is the question asked here. So what are mean by floating solar parks? Floating solar parks are simply solar parks which are floating in water. So recently the central government Union Cabinet has cleared the Pradhan Mantri Surya Sarovar Yojana PMSSY, a central sector scheme to build 5,000 megawatt of floating solar photovoltaic capacity on India's reservoir and water bodies. So this is the context of this news, which is the scheme in picture, Pradhan Mantri Surya Sarovar Yojana. So it carries a total outlay of 5070 crore and offers central financial assistance of up to 1 crore per megawatt released only after a plant is commissioned. So this is a huge project. So what's the importance of floating solar power plants in India? So the first and most important thing is that even though India is a vast country, we are devoid of land. We are land constrained country. So it addresses the land constraint of a region and utilizes existing reservoir for producing solar power and reduces water evaporation also. So how is water evaporation reduced? Water evaporation is reduced because the panel covers the water surface, reducing sun and wind exposure and helps conserve water in water stressed region. So this can be a very important project in water stressed region where hydroelectric power project also plays a major role. So one more important thing is that it has potential to improve solar panel performance. So how is it done? Because solar panels requires cooling and the water cools the panels naturally, and also lower temperature can improve photovoltaic efficiency compared to hot land based installation. So this is a win-win situation for everyone, right? So it addresses the land strain constraints, utilizes existing reservoir, it reduces water evaporation, potential to improve solar panel performance, and also synergy with hydropower also should be mentioned here, because hydropower reservoir plus floating solar makes hybrid renewable system, and hydroelectric power project can be generated anytime whenever the water is present using the potential energy of water, but whenever the sun is present you can generate photovoltaic. So solar power can be generated during daytime and hydropower can be generated during night time, and this synergy can be utilized to improve the efficiency of energy production. So these are the few points which notes the importance of solar power projects for India. Now let's see the important points related to Pradhan Mantri Surya Sarovar Yojana, PMSSY. So this was approved on 31st July 2026 under the Ministry of New and Renewable Energy. This is a central sector scheme. It's a central sector scheme. Very, very important. Central sector scheme. That means the 100% of the fund is taken by the center. And outlay of 5070 crore rupees. Floating solar target also should be noted, 5000 megawatt, and co-located storage is also the 10,000 megawatts. So solar production also happen, and not only production happen, storage is also part of this project. Storage is also part of this scheme. So minimum storage for 2 hours. This is very important, and central financial assistance of 1 crore rupees per megawatt after commission also will be given. Feasibility study report up to 50 lakh per project also will be given. India assessed floating solar potential also should be noted here. It's nearly 102 gigawatt power. Okay, so the sanction period also should be noted, 2026-27 financial year to 2030-31 financial year. So this is a 5-year long project. So that's all about Pradhan Mantri Surya Sarovar Yojana. Let's compare this scheme with other similar schemes. So Pradhan Mantri Surya Sarovar Yojana is a floating solar plus energy storage Yojana scheme, while Pradhan Mantri Surya Ghar Muft Bijli Yojana is also there. That's a rooftop solar power project, or power scheme. Okay. PM Kusum and National Solar Mission and other mission. PM Kusum aims at bringing solar energy for farmers or agriculture, including solar pumps and decentralized power. And National Solar Mission is the comprehensive mission which covers or which aims to expand solar energy production in India. So these are the various similar projects, various similar schemes aimed at improving solar power projects in India. Let's check out the next article. New Agasthyamalai eviction orders continue to silence Forest Rights Act. Forest Rights Act. So what do you mean Forest Rights Act, and what is the context of this news? So the Supreme Court has recently issued an order to evict various peoples from the Agasthyamalai Biosphere Reserve, and this is based on the Forest Rights Acts. And issue has gained significant following the Supreme Court's May 29, 2026 directions in John Kennedy versus State of Tamil Nadu concerning encroachment and ecologically restoration in the Agasthyamalai landscape. So this is a critically analyzing, this article actually critically analyze the recent Supreme Court judgment. So let's check out the context of this news first. So in 2025 March, Supreme Court has directed to conduct an extensive survey of the entire Agasthyamalai landscape and report within 3 months on violations of Forest Conservation Act 1980 and the Wildlife Protection Act. So the Supreme Court asked to survey the Biosphere Reserve, the Agasthyamalai Biosphere Reserve region in Tamil Nadu, and bring out a report in 3 months. And the final report was published in or submitted in 2026 January, and the latest Supreme Court direction to state and other authorities were based on the content of CEC interim and final report, and evictions should be made according to the report. And this article in Hindu is actually critical about the recent Supreme Court stand. So first of all, we should know where this Agasthyamalai Biosphere Reserve is. Agasthyamalai Biosphere Reserve spreads across 2 states of Kerala and Tamil Nadu. There are various protected sites in Agasthyamalai Biosphere Reserve. Let's check out the various protected sites. Periyar Tiger Reserve and Shendurini Wildlife Sanctuary are in Kerala and forms the part of Agasthyamalai Biosphere Reserve. Srivilliputtooru Meghalaya Tiger Reserve, Kalakadu Mundandurai Tiger Reserve, otherwise known as KMTR, Nellai Wildlife Sanctuary and Kanyakumari Wildlife Sanctuary forms a part of the Tamil Nadu part of this Agasthyamalai Biosphere Reserve. So these are the basics of this Biosphere Reserve. Now let's check out the basic facts about Forest Rights Acts first. Forest Rights Acts, otherwise known as Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. So this was to undo historical injustice to people dwelling in the forest dwelling scheduled tribes and other traditional forest dwellers, and this was passed in the year 2006. Okay, so based on this act, 2 rights were recognized, that means individual rights and community rights. So individual rights were again classified into habitat right to cultivation and livelihood rights, and community rights include right over community resources, forest produce, grazing, water and usage of water bodies, etc. So these are the various rights provided to scheduled tribes dwelling in forest and other traditional forest dwellers according to this act. And there is one specific date that is mentioned in this act, and that date is really important: December 13, 2005. Who had occupied forest before December 13 will be provided with this right. Only those people, those forest dwelling scheduled tribes and other traditional forest dwellers who occupies forest, the land, who had been staying in the land, who had been living in the land before December 13, 2005 had these rights, individual rights and community rights. Very important. The date is December 13, 2005. So here the rights has to be claimed first. So how do we claim these rights is the next question. So the claim should be submitted to the Gram Sabha, will approve the right after verification, and finally this right has to be approved by the final authority. The final authority is not the Gram Sabha. The right has to be finally approved by the final authority. So this rights will be examined by the committee. The 6-member committee in subdivisional and district level committee will examine the right, and finally the rights will be approved, the titles will be issued and the claims will be approved. Okay, so the composition of the committee also should be noted. The representatives from Revenue Department, Tribal Department, Forest Department and elected members of Panchayat will be included in the committee who approves this right. So this is a very important process. The approval of right is a very important process. The initiation of this approval of right, approval of the claims will be done by the Gram Sabha, and finally it will be approved at the district level, where district level committees will be composed of members from Revenue Department, Tribal Department, Forest Department and elected members of Panchayats. So very important. And forest land occupation that do not fall within the FRA scope after this process can be treated as actual encroachment. So this process has to be completely done, and you have to understand that in the Hindu article it is claimed that over many years the state governments, the forest departments and even the Supreme Court have ignored this basic legal fact. Despite the FRA having operated for 2 decades, so 1996 the act was, in 2006 the act came, and 2026 it has 20 years have already passed, and despite FRA having operated for 2 decades, no officials have asked for data on forest land occupation falling outside the FRA scope, nor has such information been presented to the public, making the data represented on encroachment and encroachers in a forum suspect. So the Hindu is very critical about this fact and says that in fact in the recent hearings the Supreme Court should have hauled up the recalcitrant state government for poor FRA implementation. The tribal department, which is the nodal department to implement the act, has also been problematically silent over these infirmities. So that's the calling, that's the take of Hindu. So the recent Supreme Court judgment has not been fair to the traditional forest dwellers there. So you have to be very critical about this analysis. Okay. Let's check out some of the misconceptions related to Forest Rights Acts. So the first and foremost misconception in the Forest Rights Act is that other traditional forest dwellers must have occupied the lands for 3 generations before 2005 for claiming their rights. So this is actually a misconception, rather it's not a fact. Nowhere does the FRA, the Forest Rights Acts, require other traditional forest dwellers to have occupied the land for 3 generations before 2005. Rather, the Act requires that the occupation should be before 13th December 2005. That's all. There is no 3 generational requirement in FRA. The Act, the Forest Rights Acts, nowhere claims that there must the OTFDs, the other traditional forest dwellers, must have occupied the land for 3 generations before 2005. No. There is only a date. Okay. And the second most misunderstood point is that commercial activities are prohibited on all forest lands or cultivation of commercial crop is not allowed. That is not the case. FRA does not prohibit commercial activities. It only prohibits those activities that threaten wildlife ecology or rights of others can be regulated in the interest of conservation and community well-being. Commercial activity is not prohibited by the FRA as such. That's the important point to note here. The next thing is that FRA does not allow sale of produce. It is only for subsistence use. Is a misconception. FRA defines bona fide livelihood needs to include sale of surplus produce arising out of exercise of such rights. So sale of surplus produce is a right according to the FRA. It is not prohibited under the FRA. Okay. And the final thing is that grazing is allowed according to the FRA, and misconception is that grazing is not allowed in forest. Grazing, the FRA explicitly permit grazing on all forest land. So grazing is a traditional right and an important livelihood activity that the FRA Acts protects. So these are the various misconceptions of this act. Even the Supreme Court has, various court has various misconceptions related to this act, and this has to be cleared, and hope that this will be cleared in the time coming. Okay. Let's check out one of the question asked in prelims 2013 prelims about FRA. Under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, who shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights, or both? The options given are State Forest Department, District Collector Deputy Commissioner, C. Tahsildar Block Development Officer or Mandal Revenue Officer, D. Gram Sabha. So we have already seen that the authority who initiate the process of determining the nature and extent of individual or community forest right is the Gram Sabha. So Gram Sabha is the right answer here. So the right answer for this question is D. Gram Sabha. So that was the final slide. That's all for today. Let's meet next week. Thank you.
Amrita IAS Academy.